Coleman, Perry, Williams, Brinkema. No, not the four horses of the apocalypse, although it may be apocalyptic for Donald Trump's administration and his Department of Justice. Those are the four federal judges, Chicago, Eastern District of Virginia, and in Miami, who in the last 24 to 48 hours are all considering what to do about fraud on the court and what to do about statements made in their courtroom that don't seem to be true, about the anti-weaponization fund and about grand jury abuse. I'm going to tie it all together for you right here with a neat ribbon on the MeidasTouch Network in Legal AF. I'm Michael Popok. Let's talk about Judges Coleman, Perry, Williams, and Brinkema and this last extraordinary 48 hours. Let's start with the anti-weaponization fund, such as it is. In the last 24 hours, Judge Brinkema, senior judge in the Eastern District of Virginia, ordered that if Todd Blanche really wants to see the case go away and wants to argue to her that the anti-weaponization fund is dead and buried, that it's null and void, that he's rescinded it, he needs to do so in a written document under oath. She gave him until the 19th, Juneteenth, to file, along with Stan Woodward, his underling, and the Treasury Secretary Scott Bessent, complimentary affidavits under penalty of perjury that they were walking away from the settlement agreement once and for all. She already rejected the argument made in her courtroom last week by the assistant U.S. attorney that, isn't it just good enough that Todd Blanche said it when he was in Congress? No. She reminded Mr. Block, this was a court of law, and you need to bring in evidence in a court of law. And so we find out as the clock struck midnight, that the government was not going to testify under penalty of perjury to any federal judge. Certainly, Todd Blanche is never going to testify in any case, in any courtroom, whether he's the Deputy Attorney General or the embattled nominee to be Attorney General. He's never going to do it, even if it means losing the case, even if it means a finding by a judge that he participated in vindictive prosecution, which happened. He's not going to testify. Or that he committed a fraud on the court. He's not going to testify. He's not going to submit an affidavit. And he's going to leave it to the senators who are going to do the cross-examination of him around the 15th of July during his confirmation battle to ask him those hard questions. Judge Brinkema gave them that deadline. Not only did they not file, they could have just missed the deadline. No, they took the opportunity to file a piece of paper to throw sand in the gears and to tell the judge to go pound sand. You don't have the authority. There's separation of powers. You can't tell cabinet members what to do. It should be good enough for you that it was said somewhere out there in the media. Yeah, it's not good enough for her. So this case will continue. She will continue to exert jurisdiction over the case. It's not moot as far as she's concerned, and she will move forward with demanding a response from the government next month in the matter. In the meantime, the anti-weaponization fund is indefinitely blocked. That's Judge Brinkema, which brings me to Judge Williams. We're waiting patiently for the filing by 34 or 35 retired federal judges to tell Judge Williams what we've all seen with our bare eyes. We've all seen with our own eyes that the Department of Justice, Treasury Department, Donald Trump's own lawyers have not carried their burden of answering the charges that they committed fraud and deceit on the court. That's what she gave them a couple of weeks to do. She said in her order, in response to charges made by the former federal judges, that they needed to answer for the charge as whether the underlying lawsuit, Trump versus the IRS, his own IRS, was an illegitimate lawsuit leading to an illegitimate settlement, leading to a bad faith creation of a settlement agreement and the fund. I mean, the cleanest, most efficient way to kill the anti-weaponization fund once and for all is for Judge Williams to declare it was the product of a unholy, bad faith lawsuit settlement with no power to do so. that if Donald Trump wants to steal from the Treasury, he's going to have to do it without the complicit involvement of a federal judge. Now, she gave them the opportunity to file papers. In my world, the world of law, you want to tell a federal judge that you didn't commit fraud on the court and you didn't commit deceit on the court, and you want to get out from under what we call Rule 11 of the Federal Rules of Civil Procedure sanctions. You file an affidavit. You better testify. You better testify under oath. But the lawyer for Donald Trump, Alejandro Brito, didn't do that. He didn't file an affidavit under penalty of perjury. He didn't testify. He didn't even he's such a coward. He didn't even look the judge in the eye and tell her that, I didn't do it, Judge. There's no fraud on the court. There's no deceit. That's how you start your papers. No. He blamed the 35 federal judges for being political hacks and tools. He said that she didn't have jurisdiction, basically called her stupid for even asserting that she could. And when we look behind those papers, looking around for affidavits and testimony from Todd Blanche to declare to the world there's no fraud, that there was no bad faith, that he had the power, it was nowhere to be found. Neither one from him, nor from Stan Woodward, nor from Scott Bessent. And that's how you stop a federal judge from throwing the book at you. Now, as soon as the judge gets that last brief in, Judge Williams now, she's got two choices. She either just reviews the briefs and makes her findings, or more likely, she's going to prepare an appropriate record for appeal, and she's going to give Trump's side one more time in an evidentiary hearing, a mini trial, if you will, to defend themselves against the charges of fraud and deceit. Serious charges. I mean, if you're a lawyer, 35 years at it like I am, if you have a federal judge make that kind of declaration, put you back on your heels with an order to show cause or something like it, you're quaking in your boots. You're crapping your pants. Those are legal terms. So I think probably early next week, and I'm tracking the story for Meidas and Legal AF, we're going to get a ruling from Judge Williams, who I know well from appearing in front of her, setting an evidentiary hearing. If that happens, I'm going to try hard to get into the room with my Florida bar card and my Southern District of Florida card to be able to report to you. Feeling sluggish? Bloated? Not like yourself. Life bombards us with silent threats. Processed foods, artificial light, and modern stressors disrupt your gut and drain your energy and weaken your immune health. Your body isn't broken. It just needs the right inputs. That's why I've been using Armra Colostrum. I've noticed less bloating, steadier energy, and overall, I just feel more like myself. Armra Colostrum is nature's original blueprint for health. Colostrum is packed with over 400 bioactive nutrients that fortify gut health, fuel fitness recovery, and strengthen immune health, supporting your best performance every day. Take back control of your health. We've worked out a special offer for my audience. Receive 30% off your first subscription order. Go to armra.com/legalaf or enter legalaf to get 30% off your first subscription order. That's armra.com/legalaf. Now that brings us to Coleman and Perry, both in Chicago in the Northern District of Illinois. Again, if you joined this video late, I'm just talking about the last 48 hours. Coleman and Perry. Both have cases in front of them of indicted people or entities that came out of one grand jury that sat for 18 months in Illinois. Who was the prosecutor that presented in facts and law and witnesses to try to get indictments out of that grand jury that met every Thursday? Sherry Mecklenburg, now been fired in disgrace. Question is, when she corrupted that grand jury, which was exposed by Judge Perry, by the lawyers for the Broadview Six, the First Amendment protesters in Chicago, where you had Andrew Boutros, the acting U.S. attorney for the Northern District of Illinois, stand up in front of a grand jury and make his own pitch and speech to get them, to coerce them to try to indict, vouching for the credibility of a case, which is a cardinal sin for prosecutors. Right? Vouching for the evidence, bolstering the evidence, and apparently doing it without having his presentation to the grand jury recorded by the court reporter. And then when you had Sherry Mecklenburg, 12-year prosecutor, award-winning prosecutor, all of a sudden succumb to the pressure placed on her not just by Andrew Boutros to indict the political targets of Donald Trump, but to the pressure back in Washington. It's simple. We've seen this well-worn pressure campaign before. Trump to Blanche, Blanche to Akash Singh, his number 2. Akash Singh to Andrew Boutros, Andrew Boutros to the line prosecutor, and we have corruption at the highest levels. And that's what Judge Perry observed. She said she never saw such prosecutorial misconduct, and she's getting to the bottom of it. The lawyers for the Broadview 6 have filed various motions. One, to get discovery, the emails between Boutros and Mecklenburg, Boutros, Mecklenburg, and Todd Blanche, Akash Singh, Donald Trump, and the rest. How high does this conspiracy go? And she's considering granting that discovery, even though the Department of Justice hoped to cauterize this wound, right, to ignore it by telling the judge, we're dismissing the indictment, we're paying their attorney's fees. Is that good enough? And the lawyers for the Broadview 6, tough-nosed, hard-nosed Chicago litigators said to the judge, Judge Perry, no, it's not. We need to get to the bottom of what happened in your courtroom, fraud on the court and deceit. The fact that they were hiding, even at the last moment, pages and lines from the grand jury transcript that you should have known about. We need those emails, Judge, and we need the correspondence and maybe even testimony. They even asked her for a special prosecutor to be appointed. Why? Because under a unique rule of the federal rules of criminal procedure, a judge has the power, if she believes the Department of Justice is conflicted, to appoint another lawyer, a prosecutor, to prosecute the case. Will we see an independent counsel or special prosecutor appointed by Judge Perry? And right down the hallway in her courtroom, in her courthouse, Judge Coleman, same grand jury, different indictment, same thing by the prosecutors. Judge, there was probably some misconduct. We're going to dismiss the indictment with prejudice. An indictment in $1 billion medical testing fraud case. They just said, we're going to throw in the towel. And Judge Coleman told them, yeah, that's not going to do it. That's Pandora's box, she literally said out loud, that you've opened, and dismissing the indictment is not going to end the inquiry of the court. And so she's looking at sanctions, special counsels, and discovery, all emanating from the same corrupt tree, the same fruit of the poisonous tree. One in Judge Coleman's chambers or courtroom, one in Judge Perry's. And all of these judges, Williams, Coleman, Perry, Brinkema, the 4 horsemen of Donald Trump's apocalypse, are right now considering whether they need special counsel and special prosecutors being appointed. Even in Judge Williams' case in Miami, I'm sure she's considering having a trusted, independent voice guide her through this thicket, since she can't trust the Trump side and she can't trust the IRS side, because they're all captured by Todd Blanche and Donald Trump. So we could be seeing not 1, not 2, but 3 independent counsel, special prosecutors or special attorneys appointed by judges in order to investigate. See, in other countries, in civil code countries, like in Latin America, even in Europe, sometimes the judge plays the inquisitor, the investigator. We don't do that in our country. The judge is the trier of fact. They need and they depend on an adversarial process with 2 parties who are at each other's throats and discovery. And then the trier of fact and the giver of law comes together and makes the final ruling. Could be the jury if it's the trier of fact. Here we're talking about judges. And they also have the inherent power and authority and requirement to protect our justice system, to protect the rule of law in their courtroom, and to use the power of contempt and the power of sanctions and the power of special counsel and special prosecutors to bring justice. And so we might have seen in the first 18 months of the Trump administration, we may have seen the shock and awe, the velocity at which Donald Trump operated, and the federal courts scrambling to catch up. But as our friend J. Michael Ludick, during an interview with me recently, who's leading the charge to file that 35 judge brief with Judge Williams in the next few hours. As he said out loud to our audience, he sees this as a turning point where federal judges are now fed up and are fighting back hard, making the last 2 years of the Trump administration one for the history books, as federal courts have figured out a way to pick that lock and restore dignity and justice to our courts. Here's a clip of Michael Luttig.
Feels like the tectonic plates of American politics shifted overnight in response to Judge Williams' call for additional briefing to reopen the case. That's how consequential this is. Why was it consequential in the first place? It's because every person in America instantly understood this as a corruption of the highest order by the President of the United States at the taxpayer's expense. When you showed America that Donald Trump had created a $2 billion fund to, quote, compensate himself, his family, his friends, his allies, and supporters, most of whom were there and responsible for the insurrection on the United States Capitol on January 6, 2021. That was a bridge too far for America. It was Americans, every single American, from the main street to the cafes, the restaurants, the bars, the streets of America, instantly understood that is a corrupt act of pure self-aggrandizement at the expense of the American taxpayers. Now, turning to the group of judges who challenged this fund before Judge Williams, I want your viewers and listeners to know that this group of approximately 200 or 300 former federal and state judges have loosely come together beginning a year and a half ago to have their voices heard about what is occurring in America today and for the past 5 or 6 years. Think about that long and hard. Never before in American history has a group of judges, retired or otherwise, ever come together, much less to speak publicly against what they are witnessing in the United States of America with respect to the corruption of the Constitution and the rule of law in this country. I could not be any prouder of this group of judges, 200 or 300 former federal and state judges.
Glad you're here on the MeidasTouch Network and on Legal AF. If you like independent journalism and commentary like this one, come over to the Legal AF YouTube channel and hit the free subscribe button. Everything that I'm talking about, all the filings and the rest, are up on Legal AF Substack for our paid members. Until my next report, I'm Michael Popok.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.